Welcome to Actual Causation, Video 2, From Risk Creation to Realized Harm. Restatement Third of Torts 28. Before we move into proximate cause, we must finish actual cause. So, where are we? We are in the doctrine of negligence. We are on the third element, which is causation. And we are addressing the first causation, which is actual cause. Actual cause is also known as factual cause, and factual cause is also known as cause in fact. We discussed the restatement third of torts, sections 26 and 27 in the first video. The second video of that series is going to address Restatement Third of Torts, Section 28. Once we're complete with sections 26, 27, and 28, that is going to conclude our discussion of actual cause, and then we'll move into proximate cause, also known as legal cause, also referred to now as scope of liability. But before we move into proximate cause, we're going to review sections 26 and 27 of the third restatement of torts, and we are going to be introduced to and apply section 28. Now, understand, please, sections 26, 27, and 28 of the third restatement of torts are not separate doctrines. One doctrine, but for causation. Sections 26, 27, and 28 are one doctrine. Okay? They answer the same overarching question. And that question is, did the defendant cause the plaintiff's harm? One doctrine. One doctrine, but three different application points. One doctrine, three different application points, right? Same question. Did the defendant cause the plaintiff's harm? Point one is section 26, which is the ordinary application of but for causation. Point two is a logical breakdown point of the but for rule. And point three is section 28, which addresses a evidentiary breakdown of the but for rule. Get it? One doctrine, 3 points. Section 26, this is our review. Section 26 is the ordinary operation of the but for causation test. Section 26 applies when we have one defendant, we can isolate that one defendant's negligent conduct, and we, in our evaluation, remove that defendant's negligent conduct, and then we ask the critical question: would the harm still have occurred if we remove the negligent act of the defendant? If the harm still would have occurred without the negligence of the defendant, we do not have factual cause. We do not have a causal link between the negligence of the defendant and the plaintiff's injury. If by removing the negligent act of the defendant, the harm does not occur, then we have established factual cause, right? Real straight, real simple, right down the center. Restatement third of Torts, section 27, is still the but for test, but it is a different version that is applied when there is a logical breakdown of the but for rule. What's the logical breakdown? When the but for rule yields an illogical outcome, we rely on section 27. When would the but for test yield an illogical outcome? When we have multiple negligent actors. And each of the negligent actors acting independently would sufficiently, in and of itself, be enough to cause the plaintiff's harm. Removing one of the negligent actions does not prevent the harm, right? The strict but for test under 26 would yield an illogical result. Section 27 corrects that logical breakdown and allows for both or the multiple negligent factors independently sufficient to cause the harm on their own to then be identified as factual causes. That means that we have more than one factual cause in that situation. 28. Here's the introduction. When would we use section 28? When we would use that version of the but for test? We would use that version when we have an evidentiary breakdown. What does that mean? That means when the proof cannot identify the cause of injury. Section 28 addresses proof uncertainty. When would I have proof uncertainty? When I have multiple defendants that acted negligently, one of the multiple caused the plaintiff's harm. We know causation has occurred, but we cannot prove which defendant caused it. That's why it's an evidentiary breakdown, right? So in 26, 27, and 28, we are still only using one test. That's the but for test. In the third restatement of torts, there is only one test. That's the but for test. Okay? Get it? One test, 3 points that will address the test. One test, 3 points that will address the test. Now, for review, we're going to go just a little bit deeper. And the reason we're going to go a little bit deeper is because I want you to see, before we go any further, that these are not 3 different doctrines. I really want you to see that they're all just versions of the but for test. And so, with your grace, I'm going to go deeper on section 26, 27, and 28. So let's look at 26. 26 is the ordinary operation of the but for causation test. Section 26. Section 26 asks a straightforward counterfactual question. Remember, this was introduced in video 1. A straightforward counterfactual question. Here's the question. Would this harm have occurred absent the defendant's conduct? This is the foundational causal test in tort law. You mentally remove the defendant from the story. You rewrite the story without the defendant's negligent conduct. Then you observe whether the injury occurs or not. If the injury still occurs, absent the defendant, then the defendant's conduct was not necessary to the outcome, which means you have no factual causation. If the harm does not occur once you've removed the defendant's negligent conduct, you see that the defendant's negligent conduct was a necessary condition of the injury, and factual causation is thereby established. Notice what's embedded in the Section 26 test. We are evaluating one defendant at a time. We can isolate the defendant's conduct. We know who did what, and the causal chain is traceable. Yeah? Now, when we don't have those mechanics, if we don't have one defendant at a time, if we cannot isolate the defendant's conduct, right? If we don't have a traceable causal chain, then we move to 27, which is addressing the but-for test when we have circumstances of a logic breakdown. So let's confront a situation where the but-for test under 26 misfires. Imagine two independently sufficient fires. Focus on these words. Independently sufficient. Independently sufficient. What that means is that by themselves, independent of one another, they would have been sufficient enough to cause the injury. Okay, so imagine two independently sufficient fires. Each one by itself would have destroyed the plaintiff's house. Apply the but-for test, and this is what we get. If we apply the but-for test as we've learned it in 26. What's that counterfactual question we're going to ask? We're going to remove the action of the defendant, right? So here it is. If we remove the negligence that created fire A, does the house still burn down? The answer is yes, because of fire B. What would 26 say? 26 would then say that A is not a necessary condition to the harm, right? Well, we've got another independent negligent act, so we have to add that to the test as well. Remove fire B from the action. Does the house still burn down? Yeah, because remember, A is sufficient on its own to create the harm. So exercising the but-for cause under normal circumstances, as we would in Section 26, is going to result in neither fire, neither A nor B would be the cause. That's logically absurd. Logically absurd. That's why Section 27 addresses logical breakdowns, right? That's why Section 27 addresses circumstances where the ordinary exercise of 26 results in a misfire. It's logically absurd because both fires clearly contributed to the destruction of A's property. The problem here, however, is conceptual. The but-for test is designed to detect necessary conditions. But when multiple sufficient causes exist, neither cause is strictly necessary, even though each is fully causally linked. Section 27 corrects this logical breakdown. And it corrects this logical breakdown by saying, when multiple acts occur, each independently sufficient to cause harm, each of the multiple acts are treated as a factual cause. That means that in that situation, you have multiple factual causes. Get it? Here's an important distinction. In Section 26, the text works normally, but for test. Section 27, the test would have failed because of what we call over-determination, right? We've got both sides independently or both acts independently sufficient negating each other if we utilize 26, right? But we still know who did what, right? We still know negligent act connected to a defendant, right? There's no uncertainty about the identification. This is a logical repair, not an evidentiary repair. This is a logic repair. That's 27. So what happens? Let's take a slide back. When I have two independent, sufficient negligent acts that would create the harm to plaintiff by itself under 27, both of those independent negligent acts will be deemed to be a factual cause of the harm. Got it? Excellent. Now, let's take a moment and do a diligent review of 28 so that we can then apply 28. Okay? 28 is used when we have an evidentiary breakdown, not a logic breakdown, but a proof breakdown. When would that happen? Here's an example. Suppose we have multiple defendants that have acted negligently. The injury to the plaintiff was caused by one of the negligent acting defendants. The injury did not arise from any outside source, right? One of the negligent defendants caused the injury, but we cannot prove which defendant it was. See, we have a proof problem. We have an evidentiary problem. That's a huge problem, right? Why? Because the plaintiff has the burden of establishing beyond a preponderance of the evidence. That is, by a preponderance of the evidence, which means more likely than not. The plaintiff has the burden to establish that. And if the plaintiff can't establish the preponderance of the evidence, then the plaintiff is supposed to lose. But when I have a situation where by all best efforts, the plaintiff can't provide this proof. Well, without the application of 28, what you're going to have is the plaintiff losing. Well, that doesn't seem fair. Well, we're not worried about fair. That doesn't seem just, right? Even though we have one undeniable cause, we have two potential origins of that cause, and we can't determine which of the two the cause is linked with. Section 28 intervenes at this precise pressure point. Section 28 asks this question. When negligent defendants create symmetrical uncertainty about which of them caused the injury that harmed plaintiff, who should bear the uncertainty? Well, Section 28 answers this question by saying it should be the defendant. Ordinarily, it's going to be the plaintiff who bears the burden of proof, but 28 recognizes a very narrow exception. 28 recognizes when each defendant acted tortiously and when one of the multiple defendants caused the injury, And the conduct of the multiple defendants make identification of which of them actually caused the injury impossible. 28 says we're going to burden shift. We're going to shift the burden to the defendants to prove that they were not the cause. This does not eliminate causation. We still have to establish actual causation, but it does reallocate the burden of proof. It does not eliminate causation, but it does reallocate the burden of proof. Section 28 prevents evidentiary symmetry from becoming the exercise of immunity that protects negligent defendants. Okay? We're going to look at the Summers v. Tice case because Summers v. Tice presents the purest form of the evidentiary breakdown that we just described that is addressed by Section 28. The injury in Summers v. Tice is real. The negligence in Summers v. Tice is undisputed. The causal source is limited to the defendants that are before the court. And even with those proof, identification is impossible. So let's take a look at Summers v. Tice. California Supreme Court confronted the situation that we've just described. Here's the situation. Two defendants act negligently. One of the two defendants caused the plaintiff's injury. The plaintiff cannot identify which one. So what are we supposed to do? Under traditional but for causation principles, the plaintiff would have lost, right? The plaintiff would have lost against both defendants because the plaintiff wouldn't be able to establish by a preponderance of the evidence which of the defendants was the one that is causally linked to the harm. The court in Summers v. Tice refused that outcome and made a pivotal change. That change was to shift the burden from the plaintiff to the defendants. The court reallocated the evidentiary burden because there were concurrent negligent acts that created symmetrical uncertainty. Let's take a look at the issue. 3-point issue. Under the principles of factual causation, should the burden of proof, right? Should the burden of proof shift to the negligent defendants to disprove causation? Should the burden shift to the multiple negligent defendants to disprove causation? When what? When one, both of the negligent defendants acted tortiously. 2, one of the 2 negligent defendants caused plaintiff's injury. And 3, the plaintiff cannot identify which defendant caused the harm. Should the burden shift? Well, Supreme Court in California in Summers v. Tice says yes. Quick review of the facts. Plaintiff and 2 defendants are hunting together. The 2 defendants simultaneously fire shotguns in plaintiff's direction. Both defendants concede that that act was negligent. Plaintiff was struck in the eye and the lip by shotgun pellets. Only one of the defendant's pellets actually caused the injury. Forensic evidence could not determine which of the 2 negligent defendants fired the injuring shot. Plaintiff could not prove by a preponderance of the evidence that either defendant individually caused the harm. But what do we know? We know that the injury is real. We know that the negligence is undisputed. We just can't identify which of the two negligent defendants the harm is linked to. If we approach this from a traditional causation problem, right, this is what we're going to have. We're going to have the evidence colliding with the reality. Let's take a look. Under the traditional but for formation, that's 26, the plaintiff bears the burden of proving that a particular defendant, more likely than not, that's preponderance of the evidence, caused the injury. The plaintiff must establish by a preponderance of the evidence that the injury would not have occurred absent the defendant's conduct, right? That is the foundational allocation of proof in a tort case. Causation is individualized, liability is defendant specific. The plaintiff traditionally has to connect the harm to a particular actor. In Summers, the plaintiff couldn't satisfy that burden by either of the defendants, right? The plaintiff could prove that there was negligence. In fact, both of the defendants admitted that they were negligent. The plaintiff could prove the injury. He's got the lip, he's got the eye, he's got the injury. The plaintiff could prove that the injury resulted from one of the two negligent parties. The plaintiff just couldn't prove which of the two negligent parties caused the injury, right? That failure by itself is significant. Do you see it? By itself, if the traditional rule were applied strictly, right, this is how the litigation is going to unfold. Defendant A moves for judgment because defendant A is going to say, well, the plaintiff can't prove by a preponderance of the evidence that it was my shot. Defendant B is going to move and say, well, the plaintiff can't prove by a preponderance of the evidence that it was my shot, right? And each of those arguments are independently correct because the plaintiff can't prove, right? At best, all the plaintiff, based upon the evidence that they had, all the plaintiff can establish is it was a 50-50 probability. Not more likely than not, but it was really exactly even. So under the traditional burden allocation, both defendants prevail, even though one of them undeniably caused the injury. That we call a doctrinal crisis, right? The plaintiff has established negligence. The plaintiff has established harm. The plaintiff has proven that the harm was caused by one of the two negligent defendants, and still the plaintiff would lose. That is under the traditional exercise of Section 26. The symmetry of the evidence, what's that? The 50-50 split defeats the asymmetry of reality. The symmetry of the evidence, 50-50 split, is between one of these two, defeats the asymmetry of the reality, which is the harm, right? And that's what we mean when we speak of structural injustice. The evidentiary symmetry, right, equal probability as between each defendant, would allow both negligent actors to escape responsibility, even though the injury cannot logically be attributed to anyone other than one of the two. That is structural injustice. So what is a plaintiff to do? With the structural injustice, the injury suffered by the plaintiff would become effectively non-compensable. Non-compensable, right? Not because there is no causation, because there is, but because the plaintiff can't identify, right? Can't identify by a preponderance of the evidence which of the two should be held liable. That pause was intentional, because could you imagine that reality? Well, that's why we have Section 28. Section 28 intervenes. How does Section 28 intervene? Like this. What the Summers Court did was, having identified the structural injustice, right? The Summers v. Tice court faced a doctrinal crossroad. The Supreme Court of California said, we can do one of two things. We can apply traditional but for rigidly, which is going to deny recovery to this plaintiff, or we could shift the burden. We could shift the burden of proof as it relates to the identification of which of the negligent parties is the link to the harm, right? And that would prevent negligent actors from escaping liability. So that's what the court chose to do. Now, importantly, understand the court did not relax the requirement of causation. But what they did was they restructured the burden of proof. They did not relax causation. They restructured the allocation of the burden of proof. This is what the court relied on. These three critical elements. One, both defendants acted negligently. They admit. Two, the plaintiff's injury resulted from a gunshot fired by one of those two defendants. And number three, the injury was not caused by anyone else. That's crucial. The injury was not caused by anyone else. The plaintiff did not present speculative causation. The plaintiff did not rely on conjecture. The plaintiff didn't simply assert someone, somewhere must have caused the harm, right? Didn't do any of that. The plaintiff narrowed the universe of possible tortfeasors to two negligent defendants, both of whom were before the court. Causation was certain as to the group of potential causers, right? What was uncertain was to the specific individual. And this is what the Supreme Court noted and used to justify their reallocation of the burden. The court made this pivotal observation. Look, the impossibility of identifying the specific tortfeasor is a product, it is a result, is because the defendant's simultaneous negligent conduct. So in other words, the reason that we can't determine which of the two is the causal link, because the two bad actors acted simultaneously, right? We have evidentiary symmetry, but that evidentiary symmetry was generated by concurrent wrongdoing on both parts of both of the negligent defendants. And what do we care about a lot in tort law? Who creates an unreasonable risk of harm? Here, the defendants created not only the risk of physical injury, but also the bad acts done by these two negligent actors created the risk of evidentiary uncertainty. And so the court said, yeah, we're going to shift the burden. The court held that once the plaintiff proves that each defendant acted negligently, and once the plaintiff proves that one of the two of them caused the injury, the burden would shift to the defendant to prove that they weren't the one. That's not a presumption of causation. That's a reallocation of evidentiary responsibility, right? Because when you think about it, it's the defendants who are in the best position to introduce evidence to clarify whether they shot the plaintiff or not. If one defendant can demonstrate that his bullet or his pellets could not have caused the injury, he's exonerated. If neither can establish that they aren't causally linked, then they both remain liable. Yeah? Got it? The most important doctrinal clarification is this. The court did not say that both defendants caused the injury. Didn't say that. The court said, it's between the two of you. Y'all show me who didn't do it, right? The court did not convert this to a 27 multiple sufficient cause scenario. The court did acknowledge that only one defendant caused the injury. And with that, the court changed who has to resolve the uncertainty. The burden shift preserves substantive requirement that the injury be caused by a negligent defendant, right? That got preserved. All the burden shift does is prevent the negligent defendants from hiding behind the impossibility that they themselves created with their negligent actions. Here's a deeper principle. At the bottom, the court recognized the strict adherence to traditional burden allocation would allow negligence to escape responsibility whenever wrongdoers acted simultaneously. And the law refuses to reward coordinated negligence with immunity. Between an innocent plaintiff who cannot identify the shooter and negligent defendants who created the impossibility of the identification to begin with, the loss is placed on the negligent actors. We call that doctrinal calibration. Get it? Summers v. Tice gives us a rule. What's the rule? When multiple defendants act negligently and one of them caused the plaintiff's injury, but the plaintiff cannot reasonably identify which one, the burden shifts to the defendants to prove that they were not the one. If they cannot exonerate themselves, they may be held jointly liable. That is the doctrine of alternative liability. Yeah? The doctrine of alternative liability rests on three normative foundations. One, fairness. The negligent defendants, not the innocent plaintiff, should bear the cost of uncertainty. Number two, risk creation. It's the defendant's concurrent negligence that created the evidentiary fog. And number three, corrective justice. A real injury caused by real negligence should not evaporate just because science cannot isolate the precise actor. Summers v. Tice completes the factual cause trilogy. 1, 26, ordinary but-for cause. 27, multiple independent sufficient causes, still under the but-for test. 28, alternative liability, where identification fails, still under the but-for causation test. All three, we're ending as we began. All three address the same overarching inquiry. Did the defendant cause the harm? Once causation is established, whether directly, structurally, or procedurally, the negligence liability analysis moves forward. And what's the next question? The next question is whether the defendant, now that they're causally linked to the harm, whether the defendant should be held legally responsible for the harm. And that is where we transition to scope of liability, also known as proximate cause. So with the end of this video number 2, we come to the end of actual cause, and our next lecture will be over proximate cause. Thank you.